What's up, everyone? It's Trevor Higgins with Fairway Mortgage, joined with my business partner, Anthony Ferretti. And today you're in for a treat. We brought our friend Graham Renfro, a local real estate attorney here, and we're going to talk about the NAR, or National Association of Realtors settlement, how it's going to affect you, what that really means. If you're a realtor, we're going to understand it a little bit more. We're going to break it down for you. And if you're a consumer, how does that impact you and what does that mean going forward? We're going to get into it all today, so make sure to stay tuned. First off, Graham, thank you so much for being here. We're proud to have you on our show, but tell us a little bit more about your background and what you do as far as an attorney.
Sure, absolutely. So my name's Graham Renfro, as you've already said, and I work for a firm in Charlotte called Chandler & Gibson. We are a full-service closing firm located in South Park, and we cover North Carolina, South Carolina. And a large part of my particular portion of the practice where I do is litigation, and specifically real estate litigation. So this is my world, these kinds of thought processes of real estate contracts, disputes, settlement agreements. That's what I do. And so what we've got today, and what I'm excited about, is an opportunity to try to clear up some of the myths and ideas that are floating around about this settlement, some of which are based in fact, but a lot of which are based out of fear. And that's okay. I mean, $1.78 billion is going to scare people, especially in an industry that is highly commission-based, where the settlement impacts the distribution and collection of those very commissions. So we're talking about the ability of people to have their livelihood and what the impacts of this settlement is going to be on that livelihood.
So if you guys don't know, the NAR, National Association of Realtors, was just involved in a settlement along with several other major firms. Can you explain a little bit more about the initial lawsuit and kind of what happened there? In layman's terms, of course.
Sure. So I actually brought it, so you can kind of get an idea of what this thing looks like and most people do not play in my world, right? Our sandbox is not a sandbox that people want to be in. Nobody walks into a lawyer's office and says, "Man, I'm having a great day today." Nobody does that. And so when somebody comes in and they want to file a lawsuit, they're dealing with a lawsuit, we draft what's called a complaint. In this particular lawsuit, they filed their case under what's called Sherman Antitrust, and that's 15 U.S.C. 1. And what the Sherman Antitrust law says is that any kind of conspiracy or agreement, and this is in layman's terms, it's not a direct quote from the statute, but any kind of conspiracy or agreement that impacts commerce or impacts the ability of money to flow between parties that adversely benefits one party over another is illegal. In a basic level, that's it. Okay?
So outside of real estate, could you give us a quick example of where that has been used in the past, or something that you could share with us to kind of understand a little bit more about what that means?
Sure, absolutely. So, if you're a millennial and you were growing up in the 90s, you most likely remember or have heard of the Microsoft lawsuit. Mm-hmm. That was Sherman Antitrust. And what happened? They settled it by breaking up Microsoft. A little bit older, Gen X, you most likely remember AT&T. The USB AT&T, same thing, broke up AT&T. Back in the early part of the 1900s, one of the largest cases that Sherman Antitrust was applied to was Standard Oil. That was J.D. Rockefeller. And the breakup of Standard Oil into the multitude of companies that happened then. It is a very useful tool in order to unclog an economic system that has been too narrowly constricted by agreements. Okay, so we like money to flow, right? I mean, you sell money. It's what you do, right?
That's what we do.
If I've got money coming from here to here, right, I want that to move freely, right? I don't want all the money to go through Anthony and get stuck in Anthony, and then Anthony hands me a penny. I don't want $5 million to go to Anthony, and then Anthony gives me 2 pennies, and then he keeps the rest of it.
Got it.
Because of fees, costs, everything else, or market manipulation. Right? So that's what we don't want. And so what Sherman Antitrust does and these types of lawsuits do is, in order to protect the flow of money and protect the consumer in their exchange of that money, we file these lawsuits, and these lawsuits are filed in order to create and protect that system and enable that to move forward. So it's a very important piece of regulation that we use. I wouldn't say often. I mean, it's fairly common, but these types where they are this large are very uncommon.
Yeah. Okay, that's fair. So as far as this settlement goes, National Association of Realtors, particularly how it impacts buyers and seller agent commissions. I mean, can you give us a brief overview of what happened in the lawsuit? And then we'll go into the impact here in a little bit. So make sure you stay tuned. But yeah, just break down a little bit of this NAR settlement. Obviously, I don't know how to read this legal language and 8 million pages of lawsuit. I don't know if you do. If you're a lawyer, good for you.
Reader's
but I
Digest
personally
version.
can't. Yeah.
Reader's Digest.
That's a little bit more than my reading material. So break it down a little bit for us.
Sure. Well, I didn't come with my my handy dandy NAR pop-up book, but we can run through a basic idea. Okay. So the idea that was put forward by the plaintiffs, and to give you an idea, we file a lawsuit. You got a plaintiff and a defendant, right? You got two parties. So you have a plaintiff, and in this case, we have several plaintiffs. And so when you hear the name Burnett is only one of the plaintiffs. Okay. So it was Scott and Rhonda Burnett. That was a couple. You have Ryan Hendrickson, Jared Bright, Scott Trupiano, Jeremy Keel, Shelley Dreyer, Holly Ellis, Francis Harvey on behalf of themselves, and all others similarly situated. And that's important language. This is what's called a class action lawsuit. And so understanding what a class action lawsuit is, the idea that we have several entities or people or whatever we have that we can form a class out of. And there are rules, and I'm not going to get into them because I think that's a little bit in the weeds as to how we form those rules and how those rules work. But when we have a lawsuit that involves a bunch of people, we don't want a bunch of lawsuits. And if they have the same complaint, if it's the same issue, so if we have just hundreds or thousands or however many that we have to do, and we don't want to have multiple cases, we consolidate it into what's called a class action lawsuit, where all of these people come together under one complaint, which is here, okay, and that gets filed, and then the defendants go through an answer period, they go through a discovery period, they can go through multiple discovery periods, they can go through multiple briefs and arguments and motions during that discovery period, and then we have a trial, and then we have a verdict. And so in this particular lawsuit, what they claim is that a rule that was promulgated by the National Association of Realtors and really kind of helped along by Realogy Holdings Corp. And if you're familiar with real estate, you understand that Realogy is one of the largest realty groups in the United States. Home Services of America, BHH Affiliates, LLC, HSF Affiliates, LLC, REMAX, LLC, and Keller Williams Realty Incorporated. Those were the defendants. And so all of these defendants were operating in Missouri. The claim here is that the defendants were taking what is called the Adversary Commission Rule, which is a rule that was promulgated by the NAR that said, mandatorily, that a seller had to compensate a buyer's agent. That's it. Now, a lot of information has been put out there saying that, it's always been negotiable. Like, we've always had negotiable commissions. Right. That's what a lot of people say. That's not the point of the suit. And the point of the suit is whether or not that rule and the forcing of the application of the rule for a seller to pay a buyer's realtor violates or interferes with the economic realities or in a standard transfer, in order that, in another way to say that it causes or impedes commerce.
So let me make sure I understand this. In the past, if you don't know, if you're not in real estate, a seller is selling a house. When that house is sold, that total commission amount would go to the listing agent / firm, and whatever their agreed upon amount would go then to the buyer's agent. Is that accurate?
That's correct.
Okay. So they're just saying the compensation of the buyer's agent from the listing agent's commission, that rule shouldn't be in place.
So what they're saying is that it's the impact of the rule. Remember, rules have impacts, right?
Okay.
Laws have impacts, right?
Yeah.
So what they're saying is that by forcing a realtor or by forcing a seller to pay a commission to another broker, that creates a situation or creates a world where brokers are going to inflate their commissions to a certain level, which is paid for by the seller, and there's no ability for the seller to negotiate not paying the other side at all, thereby artificially increasing.
So it wasn't necessarily the fact that they can negotiate. It was the fact that
It was implied.
they didn't have the ability to say, I'm not going to pay the other side at all.
That's it.
So is this actually a rule law or more so a customary practice that's been going on since the early days in real estate recording in the early 1900s?
Yeah, so sure, that's a great question. So the law has changed. Like, it's not a law, right? This is not passed by a government. This is not what we would consider a law. This is what we would consider more of an administrative rule. Okay, so the NAR is not a government entity. So the NAR doesn't pass law, right? The NAR has guidelines and mandatory rules that you have to abide by. Right, and the idea behind this commission structure at the beginning, I think we can all agree that it was arguably fairly innocuous. Right, the idea would be, well, I got to sell a house. I don't understand real estate. Jenny down the block really understands real estate. She has a real estate license. I'm going to talk to her. Jenny does work. Jenny gets paid. Well, on the other side of that, there is a mechanism, or there, is a thought process that, well, buyers also don't typically understand real estate. I can't. We have done so many deals together over the years, and we have saved people from foreclosure. We have saved people from difficult family situations. We have done a lot of things, and the reason we've done that is because people don't understand how that stuff works.
You're right,
and that's the thing. That's why we get paid, right? That's why we do what we do. And so the same applies in the realtor relationship. Realtors have education, realtors have knowledge, and realtors do work. Therefore, realtors get paid. Simple as that. The question becomes, who pays them? That's where the question becomes. And when the rule came through, the idea was, well, the seller's the one bringing in all the money, and we want to create this flow where buyers feel like they can come. It's expensive to buy a house.
Of course,
it's difficult, especially
expensive to sell one too.
Yeah, it's expensive to sell one. And so when you go through and you piece it through and you say, okay, this person's doing work for me, kind of tangentially, in that they're bringing me this buyer, and the seller's agent saying, well, I'm listing the house and getting up to where you want. The issue that has been created, and the issue that this highlights, is that there was a, and I don't want to say a understanding, but there was a mechanism that seemed to have been created whereby only properties that held higher commission rates were being shown. And so you guys are familiar with the term steering, correct?
Yep.
Yes.
Of course.
Steering is the very foundational item that we're talking about here. Now, typically in the real estate context, we don't think of steering in terms of commission. We think of steering in terms of the Fair Housing Act. We think of steering in terms of racial disparities, socioeconomic disparities, family disparities, those kinds of issues. We can't, you can't tell somebody you don't want to live in this neighborhood, like because of this person or this group of people. You can't do that. As steering, can't do that. The same theory applies in the idea of commissions. If I am a realtor and Anthony's my client and Trevor's selling his home, then if I look and I say, well, Trevor's agent, has sent me this home, this beautiful home. It's got, it's got a pool, it's got a bedroom for all the kids, there's a place for my pool table, there's a place for me to, swing my golf clubs in the garage. This is going to be great. I'm going to love this. And everything matches. Everything matches. And Anthony wants the same thing. Okay? Now let's say there are two houses there. Okay? There's your house and another house. But as the agent, even though I see your house and it's perfect for Anthony, you're only offering 2.25 on commission. I've been working with Anthony for a year. I've wasted a lot of time on this. Anthony's picky, man.
I feel you.
Anthony's picky. Have you met Anthony's wife? She's picky, man. But we gotta get that. I gotta think to myself, I've been putting a lot of work into this.
Yeah.
But you're offering 2.25. The guy down the street, not quite as good of a house, but he's offering 3. And in a $400,000 sale, that's the difference between $9,000 and $12,000.
Yeah.
That's a big
It's a big chunk of change.
Big chunk of change, that's right. And so what they showed and what the claim was in the complaint is that thought process led realtors to increase the idea of commission, increase the amount of commission, or have sellers pay more in commission so that realtors would be more enticed to steer towards their properties.
Got it.
And so that became the central item in the complaint and the central idea of the lawsuit.
Perfect. So now that we have a little bit of understanding of that, tell us more about, obviously, again, in layman's terms, the legal implications of the settlement side of things.
Okay, so
what does that really mean?
Yeah, so the settlement's interesting. And the settlement's interesting for a couple different reasons. One, it's a post-judgment settlement. Okay, that happens sometimes. A post-judgment settlement, typically when we think of a lawsuit, right, it's like getting into a fight. Like we said, we're going to the principal's office, and imagine the secretary in the front of the principal's office settles the complaint.
Thank you so much for checking out part 1. This is a 3-part series of breaking down the NAR settlement, the impact that it's going to have on you and your ability to buy real estate. So thank you for tuning in. Stay tuned to find part 2 as it comes out. And don't forget to hit that like button, subscribe to this channel for everything about real estate, mortgages, mortgage tips and tricks, and real estate investing. Make it a good one, and thanks for tuning in.